as we get started, special needs trust, please, I want you to understand as we start off that the term special needs trust means the same thing as supplemental needs trust. So special needs trust and supplemental needs trust are the same thing. So I may flip back and forth in my use of those two terms. And likewise, in your own research or your own family, if you hear someone using the term supplemental needs trust as opposed to special needs trust, don't get hung up on the distinction between those two terms. They mean precisely the same thing. So as we're looking at today and our plan today, we're going to talk a bit about basic benefits and what benefits are best preserved with a special needs trust. Then we are also going to talk about trusts themselves and how they work, what makes a special needs trust work and what doesn't make it work, distinctions in different types of trusts, and then finally, time permitting, we'll talk a little bit about ABLE accounts and how they can be used in lieu of or in conjunction with a special needs trust. Okay, so preserving benefits. Again, the focus of a special needs trust is to preserve the beneficiary's benefits. Now, sometimes we do a special needs trust well in advance, not knowing whether a beneficiary will be on any particular benefits or not, but the goal is always to keep that ability, whether the beneficiary is already on benefits or may just want to preserve qualification for possible future application for benefits. Now, special needs trusts are specifically created. They're a statutory creation, and they were specifically created to preserve qualification for SSI, also called Supplemental Security Income, so SSI and Medicaid. That's what they are made for. That's what they are best for. Now, many times beneficiaries may be on those benefits and others. They may be on SNAP, we used to call that food stamps. They may be on housing benefits. They may be on mental health benefits. All of those benefits have different rules as far as assets or income limits, and some may also be benefited or someone may also preserve qualification for some of those programs through a special needs trust, but qualification for these other benefits, SNAP, housing, mental health benefits, is not the focus of a special needs trust. Again, the special needs trusts are focused specifically on Medicaid and SSI. So let's kind of dig into Texas Medicaid and SSI just a little bit. Again, Medicaid is a state program, so many times people confuse Medicare as opposed to Medicaid. Medicare is a federal health benefit. Medicaid is a state benefit. Now, the federal government provides money that funds the state's benefits, and so Texas receives federal dollars and therefore has to follow federal law or federal rules as far as how to administer and distribute those funds for Texas Medicaid. But Texas Medicaid is different from all other states. So Oklahoma Medicaid, Louisiana, California, every state has its own Medicaid program. And when we're talking about Medicaid benefits in Texas, there are over 40 different Medicaid programs. But very often we're focused on these that you, I hope, see on your screen. Nursing home Medicaid is a common one. Then we have SSI Medicaid, and that's the program that a person's qualified for just by virtue of being qualified for SSI benefits. Then we have Medicaid for children in poverty. So we have just basic children's Medicaid that we often hear about on the news. And then we have a variety of waiver programs that you see listed there at the bottom of your screen. And many times these programs are intended for people with very profound disabilities. Often you'll see children, people who were born with disabilities or were disabled as a result of an accident. And those include STAR Plus waiver, which can be used in lieu of nursing home Medicaid, MDCP, also called Medically Dependent Children's Program, CLASS, and a variety of other waiver programs. But the key for all of these programs is they are means tested. There are income limits and there are asset limits for each of these programs. And those asset limits and income limits vary by the particular program that we're trying to qualify for. We talked about this a little bit already. Income varies by the program, so we have to know specifically what income or what program a person's qualifying for in order to know what their income limit will be. But you need to understand generally that when we're talking about in the context of special needs trusts, that income or distributions from a special needs trust are not considered income unless they are for cash, food, or shelter. Again, distributions of cash, food, and shelter are considered income, but other distributions from a special needs trust are not considered income. Resources. So likewise, Medicaid has asset or resource limits, and assets held in a special needs trust are not considered the assets of the beneficiary as long as the trust is a properly drafted and administered special needs trust. And then looking at some of the Social Security Administration programs. Again, when we talk about disability, sometimes we'll talk to clients and they say, we're on disability. And I say, well, is it SSI or SSDI? And they really don't know which of those two programs they're on. But Social Security Administration administers two separate and distinct disability programs. Both provide or both require that the beneficiary be disabled with a determinable physical or mental impairment. So we have to have a physical or mental impairment. Social Security Administration has a specific list of qualifying conditions. If a person doesn't have a condition on that list, then Social Security Administration looks at a functional test. Can they function? Are they able to work? And specifically, are they able to engage in a substantially gainful activity? Substantially gainful activity isn't just some phrase they use. It is what we call a term of art. So it's a specific definition, and Social Security Administration has a threshold, and they say, okay, if a person can work and they can earn more than, you see this figure on your screen, $1,260 a month, if they can earn that much or more, then they're able to engage in substantially gainful activity, and they're not qualified for disability. If they can't earn that much, maybe they can work a little bit but not earn $1,260 a month, then they're not able to engage in substantially gainful activity. And again, that inability to engage in substantially gainful activity has to be a result of that physical or mental impairment. Also, Social Security Administration has to find that that impairment is going to result in that beneficiary's death, or that it's going to last at least 12 months. So even if I have a terrible accident, I'm injured and can't work for a while, that doesn't mean I'm necessarily going to qualify for benefits if I'm expected to recover within 12 months. And when we look at these two programs, again, we have SSDI and SSI. We kind of have a comparison here on your screen now. And this little Venn diagram, it's a diagram with those two circles, and you'll see an overlap, which what I'm trying to show with that is if we have the people on the left on SSDI and the people on the right on SSI, there is a little sliver, a little group that's qualified for both SSDI and SSI. But in general, if a person is on SSDI, which is Social Security Disability Insurance, qualification for that program is rooted in their work record. So they were working, they were on track to get Social Security retirement, but their work life was cut short. They qualify for SSDI, and after 2 years, they get Medicare. And the really important thing I want you to understand about SSDI and Medicare is they don't have income and asset limits. They aren't what we call means tested, which means a person can have assets. So let's say that they inherited money or they had savings from before they were disabled. Those savings or those assets don't keep them from qualifying for SSDI and Medicare. But critically for our discussion in special needs trust, SSI on the right side of your screen is a means tested program, meaning it has income and asset limits. So if we have someone who needs to qualify for that disability program and they have too much in assets, then we need to use a special needs trust to get them qualified or to maintain qualification for SSI benefits. So again, SSI benefits, if someone qualifies for that, they have to have income below a certain limit, assets below a certain limit, and they qualify for Medicaid benefits very, very quickly. And typically, if we have someone who was always disabled from childhood, they'll be on SSI rather than SSDI. There are some exceptions, but generally speaking, they're on SSI. Or if we have someone who just had a spotty work record and they never really got their career off and running, then likewise, they'll probably be on SSI rather than SSDI. Again, there are some exceptions. This is quite simplified, but those are general rules to look at. So when we look at special needs trusts in particular, again, the focus of a special needs trust is to allow that beneficiary, the person that the trust is created for, to get the benefit of the money or the assets that are in the trust and still maintain qualification for their benefits. We're trying to qualify them for Medicaid, qualify them for SSI. And so we're trying to keep their benefits and let them get the advantage of the trust. And really what we're trying to do is get those government benefits to pay for their fundamental care. With SSI, they get a little bit of money each month as well as income in addition to their Medicaid. So we want to keep that and supplement it with the trust, and therefore the term supplemental needs trust, because we're using that trust to supplement rather than replace those public benefits. You see this terminology here, supplement, not supplant. Very often within the trust, you'll actually see that phrase written out, that this trust is intended to supplement and not supplant or replace those government benefits that we're trying to preserve. And it's very different from what we call a support trust. This is a little bit of legalese here, but very often we refer to a basic trust that we might set up for our children or grandchildren as a support trust. Well, this is very different because it's written much more restrictively in the sense that we don't want to disqualify that beneficiary from those important benefits that we're trying to keep them qualified for. So distributions from the trust. Again, we're concerned both about income and assets when we're looking at qualification for Medicaid and SSI. Again, income and assets are our danger zone. So we want to make sure that the trust isn't creating disqualifying income. And we also want to make sure that the assets in the trust aren't kicking someone off of benefits. So distributions have to be considered very carefully in making sure they don't disqualify that beneficiary. And we have to be careful with distributions of cash or food or shelter. Those are our three danger zones: cash, food, and shelter. Now, when I say danger zones, that doesn't mean we absolutely can't make such a distribution. It just means we have to be very careful about it, or at least consider it before we make those distributions. Generally speaking, if someone's on SSI in particular, we don't want to give them any cash, no cash, because generally cash is going to offset their SSI benefit dollar for dollar. So we need to avoid cash distributions in almost every case. Distributions of food and shelter may reduce their SSI benefits, but don't usually completely wipe it out. And so you would need guidance as the trustee on knowing when and whether you can make distributions of food and shelter. But again, cash, we generally avoid at all costs. Food and shelter, we understand it will impact qualification, but not necessarily bump someone off. Now, when I say cash, food, and shelter, there are some Medicaid benefits that completely disregard distributions for food and shelter. So for some people, like MDCP and class, we can distribute very, very freely, very, very generously for food and shelter and not impact their benefit one iota. So no impact at all on qualification for some of those Medicaid benefits. Again, these are very program specific, so you need a lot of guidance if you're the trustee in knowing what you can and cannot, or should and should not make distributions for. So if we want to avoid cash, food, and shelter, what do we use a special needs trust for? I mean, it sounds like, oh, that knocks everything out. Why on earth would we need one? Well, there are lots of things that all of us use that could be paid for directly by the trust rather than having the trust give us cash to pay for them ourselves. So for example, we have a list here of examples, but the trust could be used to pay for luxuries. Now, when I say luxury, I'm not picturing fur rugs and gold-plated toilets, things like telephones, cell phones, iPads, computers, nicer furniture, things like that. Just things that make that beneficiary's life easier, more pleasant, just more enjoyable. Any of those things, if the trust pays for them directly, generally do not count as income. Now again, if those distributions are for shelter, then it can impact some benefits and not others. Clothing used to be prohibited. It used to count as income, but several years ago now they took out that consequence, and so now the trust can pay freely for clothing without impacting benefits at all. Education and training can benefit a lot of beneficiaries. Camps and travel can benefit beneficiaries. Certainly additional care, health care, treatment, rehabilitation, many things that aren't paid for directly by Medicare or Medicaid could be paid for by the trust and really enhance the care that that beneficiary receives and certainly their lifestyle and their function in life. Now, when we look at different special needs trusts, there are different ways to distinguish them. One is the language within the trust about how the trust assets can be distributed. And I don't want to get in the weeds on this, but you'll see kind of a range of how strictly a trust can be drafted, everything from strict to broad, all the way up to totally discretionary, which I have bolded there. And I have that bolded to point out that here in Texas, generally we can draft our trust as a totally discretionary trust. And generally that's where we're going to go with our special needs trust. We're going to give the trustee total discretion when and whether and how much to distribute for that trust beneficiary. Total discretion, which is very disconcerting. If you're a parent putting money in a trust and it's a totally discretionary trust, you need to understand that that trustee has total discretion when and whether and how much to distribute to the child. But we're relying on that trustee to use their discretion to recognize there are times when a lot of money or assets need to be distributed for the benefit of the beneficiary, and there are times when they don't need as much. Maybe they're qualified for benefits that are covering the vast majority of their needs, so we don't need to distribute much. Then we decide, you know what, they're going to be much better served by a lot of asset coming out of that trust. Even if we end up sacrificing benefits, they're going to get the better benefit out of getting these big trust distributions. Well, it gives the trustee the ability to adjust those distributions according to the needs and the circumstances of the beneficiary at the time, and in consideration of the assets that are in their trust. If we just have a little bit of asset in the trust, then we might need to be a little scrimpy on how we're distributing. If we have millions and millions and millions of dollars in a trust, then we can distribute very, very broadly, and that's why we like to have that totally discretionary standard. The bigger part of our discussion here is what I have here at the bottom of the slide, the creation of the trust. And a trust can be created as a first-party trust or a third-party trust. First-party trusts are intended to receive assets that belong to the beneficiary or to which they're entitled already. And a third-party trust receives assets that never belong to that beneficiary. They never had the right to compel it or control it. And so there's a very big difference in how we can draft these two trusts and how they're administered. So we're going to break that down again between first-party trusts and third-party trusts. And whether we use a first-party trust or third-party trust is going to depend on where the money came from and how we're wanting it administered for that beneficiary. So a first-party trust, sometimes we call those self-settled trusts. So first-party trust is a self-settled trust, and also anytime a court creates a trust for a beneficiary, that is also a first-party trust. It's like the court is standing in that beneficiary's shoes and acting on behalf of the beneficiary and creating a trust for them. And again, a first-party trust receives assets that already belong to the beneficiary. Maybe, again, I was injured and already had assets in my name and I need to shelter those assets and still qualify for benefits. Or maybe they're assets that I'm entitled to but never actually touched. For example, perhaps my grandmother has passed and left a life insurance policy for my benefit. She named me, she's passed away. Now I'm entitled to that money even though I've never actually touched it or cashed the check. It's my money to take whenever I'm ready for it. That would need to go into a self-settled trust. In order to create a self-settled trust, the beneficiary has to be under age 65 when it's created and funded. So when the money goes in the trust, the beneficiary has to be under 65. It's okay if they turn 65 later or reach 85, no problem at all, as long as the trust was created and all the money was put into it before they reach 65. The beneficiary, again, has to have a disability. All of these special needs trusts are for individuals with disabilities. And these first-party trusts can be created either by the beneficiary himself or herself. If they have the cognition to do that themselves, they can do that themselves. Or it can be created for them by a parent, a grandparent, a guardian, or the court. So it can be created for that beneficiary by the beneficiary himself or herself, or by a parent, grandparent, guardian, or the court. The beneficiary cannot have any control whatsoever over that money. So again, this is a situation where the beneficiary could have controlled it, but instead they say, never mind, I don't want those assets, we're going to put those in a trust, and they relinquish any and all control over those assets. And very, very, very critically, really what distinguishes a first-party trust from a third-party trust is we have to include a state payback provision. That state payback provision provides that after the beneficiary has passed away, if there's any money left in the trust at that point, then it goes to the state to pay back all Medicaid benefits that that beneficiary received over their lifetime. Now, let's say I have a first-party special needs trust and I've been receiving disability benefits and Medicaid benefits. It's only the Medicaid benefits that get paid back, not those SSI disability benefits. But every state that has paid any Medicaid for me gets paid back their share of Medicaid. So Medicaid must get paid back at the end. And it's only after Medicaid's been paid back that anything can go to other heirs or descendants or anyone from my estate. And in most cases, Medicaid pays so much for beneficiaries over their lifetime, especially if they had an acute injury or condition, that rarely is there really anything left for family members in a first-party trust after that beneficiary has passed away. So again, if we have a trust receiving money that a person has inherited or that they already owned, it has to go into this first-party trust. Generally, you need to understand that if a person takes their own money and gives it away or puts it somewhere they can't get it, Medicaid and SSI both have rules that say, oh, there's a disqualification period for that, but it's because Social Security Administration carved out these specific rules for special needs trusts that we're allowed to do this kind of trust. So again, a person can put their own money in the trust, but we have to have that state payback provision, and we have to meet these other requirements for a self-settled trust. I'm going to kind of skip over this. I'll touch on it very quickly, but then we're going to move ahead to third-party trusts. When we talk about a trust, in particular a self-settled trust, it can be created in one of two ways. It can be a personalized trust for that beneficiary, or it can be a master pooled trust for that beneficiary. And the master pooled trust here in Texas, we most commonly see the ARC of Texas Master Pooled Trust. The ARC of Texas is spelled A-R-C, used to be Association for Retarded Citizens, but of course that terminology fell out of favor and they became the ARC. So the ARC of Texas Master Pooled Trust administers this big giant trust. It's administered, invested as one big giant trust, but each beneficiary has their own sub-account. It has the advantage that it's quite efficient, pretty affordable to set up a sub-account, but it's not going to have a lot of personal service. So think of it as a big giant bank where you have an account, but they're not going to know your name. You're not going to have an individual to call up and have a personal relationship with. They will hold your money, they will distribute your money, but they're not going to provide personal service. If we have a larger trust, we can use a personalized trust, typically with a corporate trustee, a bank as the trustee. And in those situations, we usually have a much higher level of service, much more of a relationship between the trustee and the beneficiary. And again, very often the decision about whether to go with a personal trust or a pooled trust just lies with the amount of money that's going to go into the trust. And so that's something we look at with each family. Now, shifting our focus to third-party trusts. If we have money that's going in trust for a beneficiary and that money never belonged to the beneficiary, for example, parents are leaving money to a trust for a child with disabilities, then that money should go in a third-party trust, not a self-settled trust, and we can be a lot more flexible on how that trust is drafted. And most importantly, there's no state payback provision. The state is not entitled to any payback at the end of that beneficiary's lifetime from a third-party trust. So these trusts should not have a state payback provision. Also very important to understand that these trusts can be set up for a beneficiary of any age. It doesn't have to be a beneficiary under 65. And so that 65 limitation for a first-party trust does not apply to this third-party trust. So beneficiary of any age and no state payback provision. So a third-party special needs trust is used typically in an estate planning situation where a parent, grandparent is setting it up in advance for that beneficiary. Also understand that if a person with disabilities is named as a beneficiary in a will, and maybe the trust, maybe there is a trust for them, it just wasn't drafted as a special needs trust, or maybe it was drafted, or the will was drafted so that the money went outright to that beneficiary. There are circumstances where a court can amend a trust or a court can amend a will to incorporate a trust if the court finds that that would have been the intent of the parent or grandparent, whoever left that will. So even if it wasn't originally drafted this way, we might be able to fix it after the fact. So don't give up and just assume that we can't use a third-party trust, because there are circumstances where we can do that. All right, ABLE accounts. I want to touch just a little bit on ABLE accounts. We've talked about special needs trusts. Again, big picture, we have first-party trusts and third-party trusts. First-party trusts receive assets that belong to the beneficiary already. Third-party trusts receive assets that never belong to that beneficiary. They just went straight into the trust. ABLE accounts are kind of like a special needs trust, and in some cases we can use them instead of a special needs trust. In other cases, we can use them very nicely in conjunction with a special needs trust. So if you're not familiar with ABLE accounts and you have someone in your life who has disabilities, then you really might need to look at this tool for their benefit. Very important to understand, ABLE accounts can only be used for someone whose disability started before they reached age 26. So if they were disabled at age 40 or 50 as a result of some health decline or an accident, we simply cannot use an ABLE account for them. It's only for people who were disabled prior to age 26. And they have to be disabled within Social Security standards. So that the general rules say they have to be disabled under Social Security SSI or SSDI standards, but they don't actually have to be receiving those benefits. So frankly, the rules are quite loose, and as long as the beneficiary will verify that they are disabled within these standards, then we can set up an ABLE account. Now, Social Security Administration, if someone's applying for SSI or if someone's applying for Medicaid, they're going to look closer at that disability issue. But for opening the ABLE account, it's not an overly heavy burden. You may be familiar with 529 plans. 529 plans are college savings plans that are sponsored by states, and these ABLE accounts are built on the same law that established those 529 plans, which basically means that ABLE accounts are sponsored by states. So different states have their own ABLE account, and generally speaking, a beneficiary can enroll in any state's ABLE account as long as that state allows it, and most do. Texas has an ABLE account. Many states do. The biggest one is still the Ohio ABLE account, commonly called the Ohio Stable account, and it really was the first one that was rolled out after this legislation passed, and is still the biggest. And that's our firm has the most experience with the Ohio ABLE account as opposed to other states' programs. It's quite sophisticated. They have a lot of internet resources. So if you're interested in ABLE accounts, you can access their information to get some basic information from them directly. But here are some kind of general rules. A beneficiary is limited to one ABLE account, so they can't have multiples, but any number of people can contribute to that one ABLE account. So the beneficiary himself or herself can put money into it. Parents, grandparents, friends, any number of people can put money into that one ABLE account. There is an annual limit to what can go into the ABLE account. This year it's $15,000. Additional money can be put into the ABLE account if the beneficiary is working and earning money, then additional earnings can go into that ABLE account. Here's the benefit. The ABLE account does not count as an asset, so anything in there is not an asset, much like a special needs trust, but distributions from the ABLE account don't count as income. Distributions don't count as income even if they are cash, even if they are food, even if they are shelter. So cash, food, and shelter coming out of a special needs trust counts as income, but if those distributions come out of an ABLE account, they don't count as income. So how can we use an ABLE account? Well, if we have a modest amount of money going into an intended trust, if less than $15,000 per year or up to $15,000 per year, in lieu of opening a special needs trust, a person can simply open an ABLE account and use that as their special needs trust. But also, let's say a person has a larger special needs trust and the trustee wants to make distributions of cash, food, and shelter, but doesn't want to impact that beneficiary's Medicaid or SSI benefits, then they can, instead of distributing directly to the beneficiary, make distributions to that beneficiary's ABLE account, and then when the cash, food, and shelter come out of the ABLE account, They don't count as income and don't have any impact on SSI or Medicaid. So both SSI and Medicaid exempt ABLE accounts, both in terms of assets and income. Distributions don't count as income and don't have any impact on benefits at all. Very critical to understand that every ABLE account has a state payback provision. So it's like a self-settled or first-party trust. Even if the money came straight from mom and dad into that ABLE account for the child, because it went into an ABLE account, there is a state payback provision on all that money up to the amount that Medicaid has paid for that beneficiary for their lifetime. And so any money left in that ABLE account when the beneficiary passes will very likely go back to the state to pay back Medicaid. All right, so when we talk about special needs trusts and ABLE accounts, what are some of the strategies, or where might these be relevant to us? I'm going to touch on kind of 3 different general areas where they might be relevant to you or to your loved ones. We're going to look at estate planning very briefly, then also personal injury recovery. Let's say someone has a lawsuit and they're coming into some money, then we might be able to use a special needs trust. And then also in family law scenarios, the trust can be used very advantageously. So in estate planning, if you're forming your own estate plan and you want to leave assets to someone who has a disability, maybe they're already on SSI or Medicaid, maybe we just anticipate they might be in the future, then instead of leaving assets directly to that beneficiary, you might instead want to leave the assets to a special needs trust, a third-party special needs trust for the benefit of that beneficiary. So that is a key place where we use the special needs trust very, very often. Also, in some families, they've always had the concept that the beneficiary shouldn't have assets or income because they would lose their benefits. And so in many cases, those beneficiaries, those children, were often just disinherited or written out completely. And the parents would rely on the siblings to look out for that child who had disabilities. Just understand you don't have to do that. You don't have to disinherit a child. We can set it up so that money will be there for them for their lifetime. And in the case of a third-party trust, we don't have to name the state as beneficiary. You can name whomever you want to as a backup beneficiary. But understand, if you're going to make a trust for a child, let's say I have 3 children, one has disabilities, and I'm going to name the siblings as trustees for that child, we do create a conflict of interest there. If the kids who are trustees for their sibling, let's say it's a younger sister, if they know that when sister's gone, they're going to receive any money remaining in that trust, it can, in some cases, create a disincentive for them to make distributions or to give money to their sister because they know whatever's left when she passes away will come to them. You know your family better than I ever will, but be mindful of those circumstances. So very often, even if we have siblings who are loving and certainly capable of managing money, we find that corporate trustees, a bank as a trustee, might be a better choice to protect all the interests of that beneficiary. All right, second scenario would be a personal injury situation. So if we have someone who is on benefits or we think may need to qualify for benefits, but they're receiving some amount of money from a third party as a result of an injury, then we may not want that money to come straight to them. It can go into a first party trust for them. So they're entitled to it, but they say, nope, instead of it coming to me, I want it to go to my special needs trust, or a court can say that. And in that case, the beneficiary can keep both their benefits and the advantage of that money that's coming in trust to supplement what those government benefits pay for. In some cases, a court actually requires the creation of one of these trusts. Very often, if we have a child, a minor child who's disabled as a result of injuries, or maybe they were simply already disabled and just had subsequent injuries, a court very often will mandate that child's recovery goes into a special needs trust for that child's benefit. Also, if we have an adult with disabilities who can't make their own decisions, then the court may require that person's recovery go into a special needs trust for that individual. And then finally, looking at a family law scenario. Anytime we have a divorce and one of those spouses is disabled, we may need to look at structuring very carefully what assets that spouse gets in the divorce, or we may find that it's advantageous for them to put their own assets into a special needs trust after that divorce in order to qualify for benefits. Also, in some circumstances, especially if we have an adult disabled child who's going to be getting child support, we must create a self-settled special needs trust and have the court order that that child support go into that special needs trust for that adult disabled child, so that we don't jeopardize that individual's SSI and Medicaid benefits. So it can be very important in a family law scenario if we have either a spouse with disabilities or a child with disabilities to include special needs planning in that. All right, well, that kind of wraps up what we had prepared to talk about.